So my name is Katie Warren. I'm with the Washington State Association of Head Start and ECAP. I want to welcome you all here. I'm going to mute everybody so that we can make sure that we're not getting background noise. Okay, I just muted everybody. We are really happy today to have Gil Sparks. He is the attorney for over in Wenatchee, who is a specialist with more than 20 years experience with personnel law and human call it. Okay, so can everybody hear me? Can you write in the chat? Okay. So Cheryl, I'll work through your issues after after I finish introducing Gil. We're really happy to have him. He's worked with the Chelan Douglas Child Development Association for many years, which is in Wenatchee and Chelan and Douglas County, and they have Head Start, ECAP, Early Head Start, and Child Care. So he knows the field and has worked with us many times before. The new law that is coming down the pike as of tomorrow or the next day is going to affect all of you guys. And so I am delighted to have Gil here to give an overview of that law and to answer any questions that folks may have. So take it away, Gil.
Well, good morning.
And hey, I would also want to say that if you have questions during the course of what we're doing, you can type them into the chat, and then we can also, if you're looking at this on the screen, you can unmute yourself. I have manually muted you, so you can do that as well. But we will open it up for questions after we finish the first part. Go for it.
Well, good morning, everyone. I'm assuming you can hear me. Appreciate this opportunity. Like many of you, I am working from home these days, and so the environment's just a tad different. So when the new law was passed on March 18th, or signed by President Trump on March 18th, I shared it with a number of clients. Katie was one of them, and she asked if we would put together today's session. I am happy to accommodate that, and she said I would answer your questions. I'll try to answer your questions. You all should have received the March 19th memo from our office regarding the new Emergency Paid Sick Leave Act and the Emergency Paid FMLA amendments. The last 2 weeks have been fast and furious for all of us. So there's a lot of information coming at most of us from a lot of different areas. You've got the memo on your screen now, and I'm going to try to work through it on a highlight basis. A couple of you folks have sent in questions ahead of time, which after I get through going over the highlighted basics, I will try to get to the questions that were pre-submitted. And as Katie said, if you have questions as we go along, using the chat function will probably be the most helpful way to try to get answers to you. In addition to this memo, our senior employment law attorney in our Seattle office sent an email out to all of the attorneys in our office this morning that has the frequently answered questions put out by the Department of Labor on these acts. I don't know if any of you have had an opportunity to look through those or not. 2 days ago, there were like 24, 25 frequently asked questions. This morning, there's 59. This is a dynamic, updated document. So what we sent out today may have additional information 2 or 3 days from now. And as you have questions, I would encourage you to look to that as a resource. If you have questions that doesn't answer, I'm happy to work through and with Katie to try to get answers to you on a complimentary basis. So we're all in a fairly unique situation in challenging times, and I would like to try to help out to the extent I can offer some assistance. So the first thing I want to point out to you, when this first was signed, it was supposed to be effective 15 days after signing, which we calculated to be April 2nd. The Department of Labor has since come out with its guidance and said it's effective April 1st, tomorrow. So I don't know that that impacts anybody, but I want to let you know that is a slight modification in our memo that this is effective. Katie, can you scroll down on the memo or not? There, right there. Okay. There's two sections to this new law. One is known as the Emergency Paid Sick Leave Act. And in its simplest form, it provides a new paid sick leave bank for all eligible employees. And it gives eligible employees up to 80 additional hours of paid sick leave between April 1st and December 31st of this year, when it is scheduled to sunset. We don't make any promises these days of how things may or may not stay the same, but that's the current plan. It really divides it into two components. One is if an employee is unable to work or telework related to something involving COVID-19. And so the first three bullets relate to the employee's own personal situation. And then the last three bullets relate to the employee having to take care of an individual involved with COVID-19. A couple of the early questions that we've been asked and are in the frequently asked questions section. If any of you, after this law was passed and had to close shop and you were wondering about how to pay your employees and you gave them some paid leave benefits ahead of time, those don't count toward this. This is effective tomorrow, so there's no retroactivity to this law. That said, I got an email this morning, and I'm going to call it up on my computer, my iPad, from Sandy Brown. Is that right? If I can find that. Sandy Nelson, I'm sorry. About guidance that you all received from the Office of Head Start. And they have provided you some guidance. And I've read through that guidance this morning. I had not seen it prior to this morning. But the way I'm interpreting that guidance is, even though you have actually closed physical offices, that for those employees who are continuing to work, the guidance from the Office Head Start is that those employees are continue to be paid. To me, that doesn't have a direct correlation to the Emergency Sick Leave Act. The Emergency Sick Leave Act really is if an employee is sick or caring for somebody who is sick. Two different situations. So if the employee is still working, the way I'm interpreting this guidance from the Office Head Start is you have instructions to continue to pay those employees in that situation. Now, Sandy, I don't know if that directly answers your question, but if not, we can get to it when we go through here. So basically 80 hours of additional paid sick leave for somebody who falls in one of these two categories. And then if you'll go to the next page, Katie, depending on which category they fall in really affects how they're paid. So if they're taking leave under the first three bullets, then they get their regular rate of pay not to exceed the $511 per day for those reasons. If they are taking paid sick leave to help care for somebody else, then they get 2/3 of their pay for the 80 hours. And then there's fair amount of guidance in the frequently asked questions of how to calculate that. If it's useful, I can go through that. I wasn't intending to go into that level of detail today, but I certainly can do it on an individual basis if that helps later on. So that is the emergency paid sick leave in a nutshell. Effective tomorrow, we'll see how it works. We'll see who's put on leave or not. One question, if you look at the first bullet, or item number 1 on this page, it says because an employee is subject to federal, state, or local quarantine or isolation order. The Department of Labor has interpreted that to be if the individual is subject to a isolation order or quarantine, not if the Fed, state, or local jurisdictions have issued a stay home, stay healthy order. So this is an individual's been subject to isolation, not that there's a universal request to stay home. Keeping in mind, this is sick leave again, and not just because somebody's being quarantined or isolated. In those circumstances, typically it's referred back to unemployment if people can't work because of an isolation order. And as you may or may not know, the unemployment has been supplemented by the stimulus bill that was passed last Friday, which supplements the state unemployment rules and provides an additional $600 to qualified employees in unemployment benefits. Again, I'm not intending to go into that aspect of it today, but if there is interest later on for more information on that, I can talk to Katie and we can set that up. One question I had yesterday, if you go down on the bullets, the last bullet on this page about posting notices, if you have employees teleworking, the advice being given is that the notice be communicated to them either by email or in payroll checks, envelopes, whatever method of communication you have, and you keep some record that you have made those employees notified. Okay, from Andrea, I was asked, can you repeat the last part regarding a teleworker? Okay, what I'm talking about is the last bullet on the page in front of you about notices of the new law. Employers are required to post notices, but if somebody, okay, Katie moved it. Yeah, thank you. But if somebody is teleworking, the obligation is for the employer to get that notice to the people who are teleworking and cannot come into the physical space to see the notice. So you can send it to them by email or whatever other method you use to communicate. I recommend you keep some sort of log or proof that you did provide that information to them. Okay. There are some more questions coming in. No, I'm not seeing them. Okay. Okay, so I'm going to move from the page sick leave law, and if we will scroll on down to the emergency family medical leave. As a general foundational statement for those of you who are covered by the Federal Family Medical Leave Act, this is really just another reason somebody can take family medical leave. And what it provides is, as part of that family medical leave, they can take leave to help care for an individual due to the need for leave to care for a child under 18 if the child's school or place of care has been closed or their child care provider is unavailable due to COVID-19. That's just an additional reason. So if you're already administering federal family medical leave, you just add this to the list of reasons. It is set up that the first 10 days are unpaid unless the employee chooses to use an existing leave bank to get paid. The employee cannot be required to use an existing leave bank, but they can choose to do so. And so a couple of things, nuances on this family medical leave. They can use if they have a qualifying reason, they can use the emergency paid leave in the above category to pay for those first 10 days. But again, that's an option. There's a calculation of how that's paid. It's basically at 2/3 of the employee's regular rate of pay, not to exceed $200 per day. There is, at the bottom of the page, if we can go down a little bit, Katie, to that last bullet, if any of your organizations have 25 or fewer employees, you could petition to, no, I'm looking at the wrong place, never mind. Okay, I'm getting a couple of questions. Before I go any further, let me try to answer these questions. So, from Mary, if a staff person is working remotely from home and they get sick with COVID and cannot work for a while, can they file for this emergency sick leave so they do not drain their sick leave bank? The answer is yes. If they have a qualifying reason, it doesn't matter whether they're physically at work or they're teleworking, this is available to them. Okay, the next one is Jessica. For extended family medical leave, what if they are already on FMLA due to reasons that do not include COVID-19? Do they qualify for extended FMLA? The answer is maybe. It depends on why they need the extra time. If it's for whatever reason they're on family medical leave now, if it's not related to COVID-19, that runs its course. If they have a reason that's related to COVID-19, caring for a child at home, then yes, they can access this family medical leave. Keep in mind, though, they only get a total of 12 weeks. This is not additional time. If they use time under the extended FMLA, it counts against their overall total family medical leave entitlement. So the next question from Roberto, is management required to tell workers to tell employees if a coworker has the virus? What we are given, there are a host of issues with this, and we get into the Americans with Disabilities Act, we get into HIPAA issues. What we are advising employers is that if somebody has an employee who is determining whether they're getting care or showing symptoms, that they can advise the general workforce of that. They cannot identify the employee and they can't tell them anything about the situation, just that something is going on. Okay. From Mary, can employers choose to waive the first 10 days of unpaid leave for FMLA? Can employers choose to waive? I'm not sure what you're asking me, Mary. The employee is entitled to it. Like I said, it's just another reason of FMLA. I'm not sure why you would want them to waive.
Katie, can you hear me?
Katie, I can't hear you. I can see you talking, but I can't hear you.
Sorry, Mary is unmuted and she's going to clarify her question.
Okay, Mary.
All right, so I see that the first 10 days of FMLA are unpaid.
Correct.
If we don't want to have our employees go through 10 days not being paid, can we choose to just jump straight into the 2/3 of our regular rate and start paying that employee right away?
If they have a qualifying reason, you can use the emergency sick leave for
Oh,
those first
okay.
10 days.
All right. Okay. Thank you. That answers that.
Okay. From Angela, are there still a certain amount of hours that you to put? Okay, I'm assuming that word is had, you had to put into work to qualify for FMLA and benefits. Okay, if it is related to, and I'm going to go out of the chat room for a minute, and Katie, can you scroll up on the memo to, no, too far. Go down to the intro on the merge it right there. I will have to get back to you. If you could scroll down just a little bit more, Katie. Okay, I'll have to get back to you on that question. I have to double check myself. Generally, there's one of these that you only have to be employed for 30 days. And so it has a lower threshold requirement to qualify for the FMLA rather than 1,250 hours traditionally. I believe it's this emergency family medical leave, but before I give you a final answer, I would like to go back and look at that. If you want to get a hold of me offline, you can call me. Any of you can call me for follow-up questions. It'll continue to be complimentary. And Katie, if you want to give them my contact information, either email or phone number, I'm fine with that.
Yes, I'd be happy to. Thank you, Gail.
Okay, Jean, thank you for pointing that out, the 30 days. I'm assuming you said at the top of the memo. Page number 3, okay. Go to page 3. There we go, right there. Yeah, 30 days,
Here.
first bullet. So if somebody's been employed for 30 days or longer, they're going to qualify for this aspect of family medical leave only, not for any of the other qualifying family medical leave reasons. Thank you, Jean. Okay, from Christina, if an employee contracts COVID-19, do you think that their regular FMLA would end, change to the extended FMLA, then revert back after they get well? I'm assuming that that's your question. I would think that's a reasonable interpretation. If you looked at the guidance that was sent out this morning from Karen Sutherland in our office, you will see the Department of Labor has put in a grace period. So essentially, if the employer tries to reasonably comply up through the middle of April, they're not going to enforce it as diligently. But after that, they're probably going to be a little stronger on it. I suspect the policy reason for that is we're all dealing with a new law that's been fast-tracked, and there's going to be some unanticipated consequences and questions, and they're looking for people to be reasonable in their approach and judicious in how they provide benefits to the employees. So if you err on the side of providing the employees the benefit of the doubt, you're probably safer than if you try to draw hard and fast black and white lines. Okay, Roberta, I take it by your message you want me to get back to you separately. I will do that later. So those are the only questions in the chat room right now. Just here's another one that just came in from Ruth. if you're over 60 and teleworking from home, can you get the new sick leave and not telework because of the risk? Okay, the answer is unless you fit into one of those categories, while you're teleworking, if you end up fitting into one of the 6 categories under the emergency sick leave that we saw on the first page, the answer is yes. If you're just not wanting to work because you have some concern or anxiety or personal fear, that doesn't qualify. You're going to have to fit into one of those categories to be eligible for either the emergency paid sick leave or the extended family medical leave. Okay, another question. This is too confusing. Okay, let me see if I can help. This is from Angela. Number 1, we are a small for-profit facility and still open for a very small amount of children. If we are remaining open, do my staff that are not working at all qualify for the 80 hours of emergency leave? So let me try to answer that first. Your staff only qualify if they fit into one of those 6 bullets that we are on page 1 there. If they don't fit into those 6 bullets and they're not working, then their option is unemployment. Or if they have paid other leave banks like PTO or vacation, they could access those. But if they're not sick, no, they aren't supposed to be able to access paid sick leave or the extended family medical leave. Question number 2, or if no, because nobody is sick and we're still open, but due to the stay home, stay healthy order, attendance is low, that is a reason to get access unemployment. If people are not coming in because they choose to follow the governor's instruction, then, and they're not being paid, even though you have this instruction from the Office of Head Start to keep paying them, then I would think that they will qualify for unemployment. Number 2, if a business does have to close due to not being considered essential, does the employer have to pay the employees the 80 hours? Again, the answer would be no, unless the employees qualify for one of the 6 reasons under the emergency sick leave law. If it's just because they determined to be non-essential and they're not teleworking, then that is when they apply for unemployment. Okay.
So so this is Katie. I mean, I believe I have heard from ECAP and Head Start folks that, I mean, this number really rings a chord with me, the 80 hours of sort of emergency time. Is this, you know, to the ECAP Head Start folks out there, is this just separate? I mean, I've heard from a number who are going ahead and paying people who aren't working for 80 hours. Is that part of Head Start, or what? Why is that ringing a bell with me?
I hope you're not addressing that to me because I don't know.
No, I'm addressing that to the Head Start folks or ECAP folks out here because your answer to that question sort of implied that we would be putting folks on unemployment. And I know that was a child care provider who has a lot fewer options and requirements. But yeah, if anybody wants to take a stab at answering that question in chat, that would be helpful, or unmute yourself.
Katie,
but you can go on.
Katie,
Yeah.
This is Sandy. Initially, the Office of Head Start was referring us back to, now I can't remember if it was a PI, a program instruction, or an information memorandum about disaster, and that the pandemic considered a disaster, and the federal rules allowed us to pay employee for 80 hours. So that's what that's what our agency was preparing to do. And then
Okay.
we got the notice from Head Start that we are to do more, that we are to keep staff employed, and we are to run services to the extent possible, and that we are to keep staff paid. So if there's Head Start agencies out there that are not paying staff, have laid them off, and they were Head Start staff, there were complaints registered to the Office of Head Start, and that then generated that letter that came out, pretty strongly worded, that said, no, you are to keep your staff whole. You are to pay them, period. So,
Okay.
yeah.
Thank you, Sandy. Appreciate that. I just didn't want to, I knew there was something that I was remembering. Okay, let's go on to the next one.
Okay, before we go there, Katie, one other thing is when this law came out, we had a number of employers who saw the 80 hours and decided that they wanted to give this leave to their employees early, on the belief that they would be able to take credit for having given it to them once the law went into effect. The Department of Labor had subsequently said, no, there's no retroactivity. It only becomes effective April 1st. So some agencies went ahead and gave people supplemental leave just because they chose to do it, not because it was required. But the 80 hours that are required is under the Emergency Sick Leave Act.
Okay.
So I see the question from Tara. I've got a couple more questions before that, Tara, I want to get to, and I'll get to you in due course. So from Jean, what happens if a person with COVID-19 does not have a positive test result, but just a doctor saying that all symptoms presenting the person, I got to scroll down to read the rest of this, most likely 85% or more have COVID-19. Will this meet the test? Also, what if this was, say, in the month of June, so a while in for the use of FMLA? Okay, let me try to interpret this. Katie, if you'll go back to the memo. So if you look at this under bullet number 2, it says if the employee's been advised by a healthcare provider to self-quarantine, bullet number 3 has symptoms of COVID-19. So Jean, I would think the answer to your questions is even though they don't have a positive test, if out of abundance of caution that they might have something, you probably are on safer ground to extend this type of sick leave to them. Okay, so in your second part of your question, what if it's in the month of June? Okay, so you have 2 banks here, remember. You have the Family Medical Leave Bank, and they have a total of 12 weeks under the Family Medical Leave. And that goes through this extra reason sunsets on December 31 of 2020 right now. So if they don't use it before later in the year and something comes up that is a qualifying reason, remember either the regular family medical leave reasons or the new reason to care for a child whose place is closed or for a caregiver who can't provide it, then yes, it's still available to them later in the year. Okay, so let me close this out. Tara, it says that FMLA after 10 days is paid. Employer has to pay. FMLA is typically unpaid. So if you go back, Katie, to my memo, or to the memo, and you scroll down to the family medical leave section, right there, you will So you don't have to pay the employee their full salary, but you would, or wages, but you would have to pay them 2/3. Go down one more bullet, Katie. Yeah, the 2/3 right there. That's what you would have to pay them. Now they can supplement that 2/3 with any paid leave banks they have. And it's quite possible, because they have reduced hours, that they could apply for unemployment to supplement that also. Some of that's going to have to work out through the system as we go through. But that's what I believe is the answer right now. Okay, going back, let me go back. Where did Tara's question go? Okay. Head Start kneecap says it will be acceptable to pay those staff through those funding sources, even if we are closed. Yeah, that's how I read it. That I don't know about those sources, but to count against their bank, I don't know where you're going to be pulling the money from, but it is paid time, and it looks like the Office of Head Start is going to make sure that that's an allowable expense. Okay. I believe that answers all the questions in the chat room. So I'm open to anything else. Katie, where do you want to go from here?
Yeah, any other questions out there? I have to say that I understand this a little bit better now, but it's really confusing. There just seems to be so many different things to think about. I really don't envy you guys trying to figure this out. All right.
Okay, so what does a raised hand mean? Mary McDonald has a raised hand.
She can unmute herself. She's not muted on my end. Mary, do you have a question?
Go ahead, Mary.
Yeah, I do have a question, and I'm not that fast of a typer, so I thought I'd squeeze one in. Yes, Head Start did say clearly pay your staff. My question is, and it might be to other policy, not so much law, but maybe other directors could chime in. So we're paying our staff. We've been told to pay our staff. And is it okay, or should we be using, let's say this goes on 3 months, is it okay to be using, when I have a staff person that says, hey, I want to go on a vacation. I guess they want, I don't know, for some reason they want to excuse themselves from work for a couple of weeks. Is it okay to use vacation pay? And those pay things that are just regularly in your policy, like you were paying them normal. Well, we usually use sick leave, and we've got emergency sick leave now, and we use vacation pay. I'm confused about if that should be in or out with this Head Start initiative. In some ways, I think, well, maybe that's just out the window. We pay them regardless, and we don't track those kind of things. So I guess my question is kind of fuzzy, but that's what it is.
Okay, so Mary, in listening to that, if you've got employees who are still working and they want to take time off for whatever reason, it seems to me whether they're working at your physical site or teleworking, then you would apply your regular policies and make your regular decisions on whether you will grant them time off under those policies. These new laws are really for situations related to people needing time off because of some COVID-19 related reason. It doesn't mean you can't go ahead and use your regular policies to run your workforce. That help?
Yes, it does. Thank you.
Yeah, and it looks like the people are doing the same. They're following their existing leave policies. Did you get Jean's question, Gil?
What's that? I'm glad I agree. Okay, anybody else?
I think Jean has a question.
Jean, you want to unmute or you want to type?
I think it's typed. Do you want me to read it? Is
Well-
emergency FMLA? Oh, go ahead.
So my question is, as I read the first paragraph of the emergency FMLA amendment, it seems to me that it is applying just to parents with children that are out due to school closures or childcare closures. So this paid FMLA is specifically targeted to parents. It is not a paid FMLA if you get COVID.
Okay, so the FMLA, you are correct. As I said at the onset, this is another reason to qualify for FMLA.
Can you
It's
repeat that, Gil?
qualified
You
under-
were a little.
Yes, I can.
Yeah, Gil, can you? Yeah, we had a little bit of a glitch.
Sure, no problem. So I think your interpretation is right, because this is just one more reason to qualify for FMLA. If an individual gets COVID, they likely have what is known as a serious health condition, which is a qualifying reason for FMLA. Separate from this, you just don't have to pay them under this program. And this reason for FMLA, when they're taking care of a child or need to leave, they are entitled to this 2/3 pay at their regular rate of pay. If they're taking regular family medical leave for a different category, this would not apply.
Okay, that's good. I appreciate that clarification. So, like you said, if someone gets COVID and they want to initiate use of FMLA, we as an employer do not have to pay them. We just have to follow the FMLA rules.
That's how I'm interpreting it at this point. I would encourage you to keep your eyes on the Department of Labor frequently asked questions and see if the guidance changes, but that's how I see it right now. You're welcome.
All right. Any other questions? Well, thank you, Gil, and thank you, everyone. I will collect all this information and Gil's contact information and send it out to all of you folks who participated in this call. And this will also, we'll make a video available too if you have staff who, senior staff or whatever, who want to hear the Q&A as well. So thank you all so much. Really appreciate Gil's expertise and willingness to support ECAP and Head Start and child care in this troubled time, and hope you all have a great afternoon.
Thank you all.
Thanks, guys. Thanks, Gil.
You're welcome, Katie.